Okay, guys. Sorry, Ryan's here in the office with me, so if you see me looking away, I'm looking at Ryan. He came up today to help me with a few things. So it's about 8:23. Sorry, I'm a few minutes late. We just got back from Mizzou. We went down to Mizzou today. My daughter Allie had family weekend, so we spent the day yesterday and today with her, and got back a little late. So I apologize for that. That's why I'm still, looking a little disheveled. Normal person. I'm not some aristocrat. Uh, so let's talk about this. There's a lot of different components to this Safety Act. I've been focusing on this no cash bail provision. It's been a hot topic, right? And so 100 of 102 of the state's attorneys in Illinois have a problem with this. There's been three lawsuits filed uh, raising some issues about it. There's probably a few other issues. We can talk about those at a later date. But for now, I just want to talk about what the statute says. Because what you have with Governor Pritzker and Kwame Raoul and some of their mainstream media outlets like the AP and Chicago Tribune, they are really the Department of Misinformation in the state of Illinois, because they just make things up that they expect people to believe. And so I'm going to do the same thing right now that I've done for the last couple of years. I and Janelle, my friend Janelle, just said having flashbacks, because that's exactly what I'm going to do. Ryan's going to pull them up on the screen in a second, but I'm going to give you the documents, the statutes themselves, and let you read them. Because when you do that, you're going to realize that what J.B. Pritzker is saying and what Kwame Raoul, Kwame's not even really talking right now, because he's probably going, they figured it out, because he helped orchestrate this thing. So he owns it, right? He's the attorney general. Yeah, Governor Pritzker's got a law license, but, having a wing on the law school named after you probably helps with that. Doubt he's ever practiced law. Kwame talks about how grand of a, attorney he is with all his prosecutorial experience. And I was just a lowly criminal defense guy for a part of my career, but I know how to read, so maybe we need to help Kwame pick that skill back up again. So anyway, we're going to talk about this issue of someone is alleged to commit a crime, whether they're going to be held in jail pending the trial or whether they're going to go out. Okay? This is what we're going to talk about. That's all we're going to talk about tonight. So to the extent you guys start putting things over here in the column of comments about world peace or something else under the sun, just save it for a different day. We're going to talk about when someone commits a crime, allegedly, can they be retained or not? What does the statute say? And I'm going to point you to three parts of the statute that deal with this, okay? Ryan just pulled up here one of the main provisions, and you guys will have these available to you, but I'm going to point out a few things of what they say. And this talks, and you can see here, you see where it says effective January 1st, 2023. You see that right at the top? Ryan, I got my little, here. See where it says that? 2023. Denial of pretrial release. Pretrial release means after you've been arrested, you go in front of the judge. Are you released pending the trial, or are you have to stay in jail? Let's go to Part A right here. See Part A right there? I want you to read that. Upon verified petition by the state, the court shall, and the word shall in the law means it's absolutely required. Okay, it's not may, it's shall. They shall hold a hearing, and they may deny defendant pretrial release. So denying them pretrial release means we're holding you in jail. Only if, that's the key language right there, only if. The court may deny your release only if. So what that's saying to you is that, and we're going to get to them here in a second, these categories, there's 7 of them. If what you've alleged to, go back up a little, Ryan. If what you've alleged to have done does not fit one of these 7 categories, does not fit, the court must release you. That's what this statute says. So when the governor is trying to tell you, oh, that's not true, it's not true, it is true, it's in the statute. Because unless you've committed one of these 7 categories of crimes, you're never going to see the judge. You're not going in front of him. They're going to let you go within 48 hours with a little citation saying come back to court on a particular day, okay? Because you can only be detained if you commit one of these 7 categories that we're going to talk about. So, step 1, there's a 2-step process I want you to understand. Did the alleged criminal commit one of these 7 categories? Yes or no? If the answer is yes, then there will be a hearing with the judge for a judge to make a decision. That's what we'll talk about in a second. If the answer is no, they did not commit one of these categories of crimes, they are to be let go within 48 hours. Period. It's that simple. Ask any state's attorney in the state of whatever county you live in. Is that true? They will all tell you yes. So let's go over some of these 7 categories I want to talk to you about, okay? Number 1, the defendant is charged with a forcible felony. We'll talk about what forcible felony means in a second, for which a sentence of imprisonment without probation is required. What this means is that if you are charged with a certain type of crime for which if you are convicted, you cannot get probation, you must spend time in prison, you fit this category of number 1. Okay? I'm going to repeat it again. I want you to understand it. Category 1 here, number 1, is a type of felony that if you commit it and you cannot get probation. So there's 2 components to part 1. Is it a forcible felony? Yes or no? Second, is it a forcible felony for which if you're convicted, you must go to prison, you can't get probation? If it meets both of those, then you fall with under category 1, and then you may have to you're going to go have a hearing with the judge, and you may have to stay in jail if the judge orders it. Number 2, and I'll go through some of these pretty quick, okay? The first one's one of the most important ones. I'll come back to that one. Number 2, the defendant is charged with stalking or aggravated stalking, okay? And there's a potential threat to the safety of the victim. So in this one, if you have been charged for stalking or aggravated stalking and there's a potential threat to the victim, then you may be detained after you go have the hearing, and the judge makes a decision. We'll get to the judge's part next. Right now I'm talking about, have you committed a crime where the judge even has a say in it? Number 3, there's a victim who is an abuse by a family or household member as defined in the Domestic Violence Act, and you were subject to an order of protection. What that means is if someone had an order of protection against them on behalf of a family or household member, and there's some abuse while that order of protection was in place, you fit category number 3, okay? Number 4, charged with domestic battery or aggravated domestic battery. Again, we're not going to go into the details of what these mean. You get the point. That's number 4. Number 5, it lists all a certain part of the code. What those are, I'll just tell you, those are the sex offenses. Those are a variety of different types of sexual offenses. So again, if there's a sexual offense, you may be detained if the judge says so, but we'll get to that later. Number 6, these are a bunch of different types of firearms charges. You can see there, if you read down through there, there's firearms and there's some, indentured servitude, things like that. Number 6. So let's really call it the firearms category. Number 7, the person has a high likelihood of willful flight to avoid prosecution. High likelihood of willful flight to avoid prosecution, and is charged with the felonies up above or a felony other than a class 4. So really what this one means, it's a kind of a catch-all. This says if you've been charged with any felony offense other than a class 4, which is the lower felony, and you are a high likelihood of willful flight, you may be detained if the judge says that it's necessary. You can read these 7 categories at your leisure, okay? But what I want you to understand from this, go back to the top, Ryan, that all the way, sir, all the way to the top. unless one of these 7 categories you've alleged to have committed, you cannot be detained. The judge will never see you because the state's attorneys have said it's not in these categories. All right? So let's talk about the first one again. Go back where it's one of the bigger categories. The forcible, no, go up the top. Number 1, the forcible felonies for which you must go to prison. All right? This is because you've seen the memes that talk about kidnapping and robbery and stuff like that. I want to show you why this is. Part 1 is a 2-part component. Forcible felony, must go to prison, can't get probation. Ryan, go to the definitions of what a forcible felony is. These are, here's another provision of the law, you'll have it available. These are forcible felonies right here. So this is the list of cases that meet the first of the 2 prongs of that one part. These list all the forcible felonies: first-degree murder, second-degree murder, the criminal sexual assaults, which are a different category. Here, see the kidnapping? See kidnapping and aggravated kidnapping right here? See those? See burglary, residential burglary, robbery? See all those? Those are all types of forcible felonies. The question then becomes for you, what of these forcible felonies must you go to prison? And you cannot get probation. It has to meet both parts, because all of these forcible felonies listed here, there are many of them, several of them, for which you don't have to go to prison. You can get probation. And if you can get probation for these, go back to the other one we started with, Ryan, you cannot be detained because it says forcible felony. So where imprisonment is required, you can skip the, with probation, periodic imprisonment. Imprisonment is required. So those forcible felonies, go back now to the third one, Ryan. Go to the third page document that we got, the 5-5.3. Okay, here's another one that you can read through. This is actually a list of the types of crimes for which you must go to prison. Okay? So let's think about the one, second-degree murder. Okay? Go back to the forcible felonies, Ryan. You see where second-degree murder is listed as a forcible felony? The next step is must you go to prison? The answer is no, but go back to the one we were just on. Scroll down. See here, first-degree murder, attempted first-degree murder. Oh, there's a gap right there. Guess what? Because second-degree murder in Illinois, you may get probation, possibly. So go back to the first document that we were talking about, Ryan. Number 1, forcible felonies for which you must go to prison. Kidnapping doesn't fit in there. That's why you cannot be detained, because it doesn't fit any of these 7 categories, specifically the one we're talking about, number 1, because it's conjunctive. You have to have both. So when you hear Governor Pritzker and these people that don't know what they're talking about going, oh, the judge can still detain, he can still detain. Not under this law, he can't, because only if. You may deny pretrial release only if, which means you must give them pretrial release if they don't fit these categories. Kidnapping is a forcible felony, but you can get probation. So since imprisonment is not required, you can't detain them. Does that make sense to you guys? It's really that simple. When you look at these 3 documents that I've just given you, that's why it is. Second-degree murder, kidnapping, robbery, okay? Basic robbery. Go back to the forcible felonies. See where it says right there, robbery is a forcible felony? But go to the document on what requires, Ryan, on the 5-5.3. If you go through this document, you will not find robbery having a mandatory prison time. You know what you will find? You'll find armed robbery, with a weapon. That is something that if you commit armed robbery, yes, you may be detained. Another one, burglary. Go back up, Ryan, to G on that document. Go to G. See there, see residential burglary? Residential burglary, imprisonment. Now, there's a little exception with a task probation. Set that aside as it deals to substance abuse. But residential burglary, go back to the forcible felonies, Ryan. See where it says burglary and residential burglary? So while burglary itself is a forcible felony, it's not mandatory prison time. So you can commit burglary and you can't be detained. Guys, I'm not here to say that they intentionally did this. There are some that would say they would. But the reality of it is they took this comprehensive law and they crushed it through the legislative process in 3 days. And so these types of things that we're talking about is what happens when you do that. And so you have a whole, you know what is, go back to the very first document, Ryan, our 7 categories. I'm going to go through these 7 categories real quick again. Number 1, forcible felonies of which probation is not possible. You got that, right? Number 2, stalking and aggravated stalking. Number 3, you abuse somebody while there's a order of protection in place. Number 4, domestic battery or aggravated domestic battery. Number 5, the sex crimes. Number 6, weapons crimes. Number 7, the high flight risk. You know what category of crimes is not in here anywhere? All the drug offenses. None of the drug offenses are listed whatsoever. So unless you have a drug offense that's a class 3 or higher, and they can prove high likelihood of willful flight, which is very, very complicated. I'll talk about that in a second. Any drug offense you commit, you can't detain them because they left them out of the 7 categories. Does that make sense? Okay. So you can read through those and you can put that together. And I'm going to summarize it for you one more time. Look at the 7 categories. If a crime that someone is alleged to commit fits one of those 7 categories, they may be detained once they have a hearing in front of the judge. If they do not fit within those 7 categories, which kidnapping's not, second-degree murder's not, robbery's not, straight burglary's not, no drug offenses are in there, they can't be detained. And ask your state's attorney that question if that's what this statute says. That's what it says. Okay? So then, let's say that they fit one of these categories. Then the question comes, is the judge going to detain them? Because then, if they've fit one of these categories, then the judge gets to have a hearing and decide whether or not they should be held. Because a judge may decide, even though they fit the category, he may not think that they need to be held. He might release them under some conditions. The judge will then have that discretion, according to this law. But you got to get in front of the judge first. And for all, I'm going to say it over and over in 100 different ways. But for all of the crimes that don't fit within those 7 categories, judge never sees those people. Because the legislature is trying to say, we've already decided for all of those crimes that they need to be released. And judge, we're taking that discretion away from you. And we're going to say, let them out. You committed straight old burglary or straight old kidnapping. We're telling you, let them out of jail. Judge, you don't get to decide whether that's a good decision or bad. That's what your legislature tried to do, unwittingly or not. But let's go to the next step. I'm going to jump in. Mr. McGuire says, Tom, you're being nice. They did this purposely. You might be right. I'm just analyzing the law. I'm not even getting into the politics yet. Let's say now we go to the next step. And we say they've committed one of these offenses within these 7 categories. Now we got to go see the judge and have a hearing with the judge. What does that look like? What is the judge going to be doing, right? Well, let's go back to the 6.1, Ryan. And in 6.1, go to Part C. We'll talk about Part C first. Oop, you blew right past it. timing of the petition, okay? Simply speaking, within 48 hours of when someone first appears, they're going to have this hearing. Now, we're not going to get into the logistics of how that's going to happen, but they got to have it. Let's call it a 48-hour hearing, okay? What does the state have to prove, right? What do they have to prove to the judge? Because now the judge is going to say, should I detain this person or not, because they fit these categories. Go to Part E, Ryan. Here you go. All defendants shall be presumed eligible for pretrial release. So they're saying, we don't care what crime you committed, even if it's first-degree murder, you're presumed eligible. All right, let's go on. And the state shall bear the burden of proving by clear and convincing evidence. That's a pretty high standard, clear and convincing evidence. Okay, what does he have to prove? What does the state have to prove? Number one, the proof is evident, or the presumption great, that the defendant has committed an offense. So you, for those lay people, you have to say, the state almost has to do a pretty good job of showing that you actually did what you've been alleged to do. That's an oversimplification, but it's not completely unreasonable. Part two, that the defendant poses a real and present threat to the safety of a specific identifiable person or persons. Okay, so you have to show a real and present threat to a specific identifiable person. Does it say a real and present threat to the community or to society as a whole? Doesn't say that. A specific identifiable person or persons. And if the state is also trying to prove that it's a high likelihood of flight, because remember number 7, the catch-all number 7, go to it real quick, Ryan. I know it's going to take you got to scroll up. Remember, you just blew past it. Number 7, where it was potentially holding somebody for a high likelihood of willful flight. Remember that? I'm going to read to you what that means that they would have to prove. That means they're planning or attempting to intentionally evade prosecution. Read it again. Planning or attempting to intentionally evade prosecution by concealing themselves. Simply past non-appearance in court is not evidence of future intent, which means if you didn't show up in prior cases, judge can't even consider that. They have to show that you're planning or attempting to intentionally evade. It's a very high burden. But again, that's another requirement at this hearing. So you have the hearing. Can they prove to the judge by clear and convincing evidence those elements? If they prove that to the judge can then detain them pending their trial. If they don't prove that, no matter what the offense, the judge has to set them free. Those are his only two options under this law. Set them free, detain them. So let's say the judge sets them free. Says, okay, I'm going to let you out. Here's your date. Be back here in court on, I'm just going to pick a date. October 15th, return to court for continuing to this process. All right? What happens when they don't show up on October 15th? What do we do? Well, what we do now under the law is if you don't show up for that hearing, the judge issues a warrant for your arrest because you failed to appear for the process. Warrant for their arrest. That warrant then gets entered into what's called the lead system. And that warrant will be seen, let's assume it's a statewide warrant. That warrant can be seen by every law enforcement officer in the state of Illinois. That person gets pulled over. They see an outstanding warrant. They arrest them, take them to jail, go see the judge. Hey, you didn't appear on October 15th. Sometimes that process takes a while until somebody gets picked up. Because here's what doesn't happen when somebody doesn't appear on October 15th. Law enforcement doesn't go looking for them, ladies and gentlemen. It just doesn't work that way. They don't have the time, the effort, or the resources to go look for everybody that doesn't appear in court. The warrant gets issued, it goes into the system, and law enforcement across the state hopefully will eventually get them. They'll get pulled over for a traffic ticket or some offense like that, and then they'll run their record and they see there's a warrant. That's how it works now. On January 1st, they wipe that out and they replace it with a toothless civil process. I'm going to explain to you what that's going to look like. So you don't show up on October 15th for your hearing after the judge lets you out. Okay? Don't show up. The state has to issue what's called a rule to show cause. Rule to show cause. The judge will issue an order to show cause that says, hey, you didn't show up on October 15th. You need to be here now on November 15th. And here's the order. You know what they got to do with that order? Somebody has to physically take that order that the judge just signed and serve it on the defendant. Are you with me? Got to serve it like serving a summons. You guys are familiar with that, right? Got to take that order, serve it on the defendant that didn't show up. And if you don't serve it on them within 48 hours prior to November 15th, they don't have to show up. They're not doing anything wrong. So law enforcement, not that they don't have enough to do, would have to then, for every person who does not show up for their hearing, go and try to take the order of show cause and serve it upon them. You want to talk about a disaster. There's a disaster for you. Because let's say somebody got pulled over for a crime. Let's say they're doing something and they don't live in Illinois and they get released and then they go back to, let's say they live in Arizona and they don't show up for their court hearing. How are you going to get an order to show cause served on them? You're not. So that crime may never go resolved. But let's say you have this order to show cause and it's somebody in the community or somewhere in the state. Let's say they actually have the time and the effort to go serve that person. And you serve them, then they don't come to court. Then you can get a body attachment against them, like we used to be able to do right at the beginning for missing the first hearing. Now, after they miss the second hearing, hypothetically, you can get a body attachment, and that body attachment will go into the lead system to potentially get them picked up to get back into court. But the big caveat of that is, and I want you to understand, is that they get what I'm calling a get out of jail free card the first time around, because they know if they miss that first date, nothing's going to happen to them other than the judge issues an order that somebody's got to find them and serve on them. And then once they get served with it, then you might say, oh, I better show up now. That whole process is going to become so cumbersome that it's going to collapse upon itself, because these alleged criminals are going to realize that there's that gap in there, right? And they're going to realize that law enforcement doesn't have the time to be sending people across the county or across the state serving people with an order to show cause. Because let me give you a real life example. I live in Bond County, Illinois. And let's say somebody has alleged to commit a crime. They go in front of the judge releases them. They go away. Or let's say that it was a crime that they couldn't be detained for, but they still got charged with it. They're going to be released automatically, never see the judge, and they have to appear on October 15th, and they don't show up, and the Bond County judge issues an order to show cause. And let's say that person lives in Cook County. You know, it's a big county. I'm not disrespecting our biggest county. They're busy. How is a sheriff in Bond County, Illinois, ever going to get somebody in Cook County to serve that order to show cause before the 48 hours before that next hearing? Guys, it's not going to happen. It's not going to happen. Say they will in Will County. They live in Grundy County. Trying to get that order served is never going to happen. And just so you're clear now, if they don't show up in Bond County for a hearing, a warrant gets issued for their arrest immediately that goes into the lead system. And then if they get pulled over for something in Cook County or Will or Grundy, then the law enforcement will see that warrant and they'll detain them and send them back to Bond County. It happens all the time. People that are involved in the system don't see it, but it happens all the time. That's gone. And so that whole, once somebody's been released, and how we then process and keep those cases moving to come to resolution for not only the court system, but for the alleged criminal too, that needs to be over. That whole process is going to be Catastrophic. Catastrophic. So that's what I wanted you guys to understand. There's a lot more to this whole cashless bail thing that I'm going to be talking about coming up. There's some other issues too. But this issue is, I'm going to give it to you again in summary. Whether or not someone can be detained is based upon the 7 categories. If they fall within one of those 7 categories, then they potentially may be detained if the judge thinks it's necessary. If they don't fall within one of those 7 categories, they cannot be detained, because it says only if at the top of 6.1. Okay? So if they don't fit the categories, don't ever see the judge. Turn them loose with a notice to appear in the future, almost like you get a speeding ticket. And then if you don't show up, you just heard me talk about that. But they only get to the judge, guys, if they've committed one of those categories. Crystal clear. It's not even a question whatsoever. Every state's attorney agrees. That's what it says. Kidnapping, robbery, second-degree murder, they don't fit the 7 categories. They just don't fit. It's that simple. Then if you get to the hearing with the judge, if he detains you without bond, he's detaining you without bond. If he releases you, where's the incentive to come back? You've not posted any money. So if you don't come back, you don't lose any money, because when you post bail and then you don't come back, you lose your money. So there's no money posted. If you don't come back on the day you're supposed to, they can't arrest you. They can issue an order to show cause and then try to find you and serve it. That's the process that they passed through at 3 o'clock in the morning on January 13th. And I'm going to leave you with that process. So now that you understand that, and I will go over that as many times as I need to, but that's what it is, okay? And I'll read some questions in a second. But let me tell you how this thing got passed. Back in the spring, early, maybe even winter, I think it was February 2019, this House bill that became the Safety Act was presented by a gentleman out of the House, I believe, named Mr. Tarver. He put this bill in front of the House of Representatives, your House of Representatives. It's about 7 pages long, that said, if someone's incarcerated and they're going to be released because they'd served their time to society, within 45 days prior to them being released, we need to give them information about how to register to vote, etc. I'm all for that. I don't know any person that would not be for that. I'm fine with that. That's how it started. So once that was presented, it went through the whole process in the House of Representatives. I'm not going to go through all of that. And it passed. They voted on it. Our House of Representatives voted, said, yeah, that's great. That was in April of 2019. That bill sat in the Senate, dead on arrival, never got touched. And in January of 2021, almost 2 years later, 3 days before your General Assembly was scheduled to come back into session under the new General Assembly, because the election had occurred and you had new members coming in, you had other members going out. So they were in what's called a lame duck session. Does that make you guys familiar with that? So at 12 o'clock on January 13th, brand new General Assembly was coming in. On the 10th of January, just 3 days prior to the new General Assembly, and almost 2 years after this voter bill for people coming out of imprisonment was in the House, L.G. Sims, oh, Mr. Sims, in the Senate, does what's called a gut and replace within this 3-day period. He takes and makes what was a 7-page bill, now 700 pages, covering over 200 amendments to statutes, and this cashless bail being one of the provisions. Crammed it through in 3 days. And they started the process, the final process, about 3 o'clock in the morning on the 13th, the last day when you're all asleep. And they had to get it voted on, and they eventually get back to the House of Representatives, because once it passed the Senate, this gut and replace of all this new stuff, it doesn't go back to the House of Representatives to be completely re-discussed so the people can see it. Oh, no. The House of Representatives just gets to vote on it. They needed 60 votes out of the House. At 11 o'clock, an hour before your new General Assembly was scheduled to take over, they still don't have the 60 votes. They got 59. There wasn't any Republican that was going to vote for it. And they couldn't hardly get, there were 70 some Democrats, but they only had 59 because everybody knew what was going on, right? The sham of a legislative process. So within an hour left, they had 59 votes. And the process, the way it works is they'll go, last call going once, last call going twice, last call third time, and they'll close it for voting. And if you don't have enough votes, then it fails. So the Speaker of the House starts calling and actually calls third and last and final call, but yet doesn't close the vote. And there's chaos on the floor of your House of Representatives. I've talked to House members about chaos. They're cussing each other because they can't get the 60th vote. And then, wouldn't you know it, before they finally close the vote, about what I'm told, a half a dozen Democrats start walking with this person who hasn't voted yet, walk them to their place of sitting. Walk them to it. And that person pushed the button with all these people surrounding them. Now, I've heard stories about what encouragement that might have taken, but I digress. But it passed with the 60 votes an hour before your new General Assembly taken over. After being 700 some pages, covering 260 statute amendments in 3 days. That's how this behemoth became law. And then it didn't come into effect until, guess when? January 2023, 2 months after your election for governor. Do you think that was a coincidence? It wasn't a coincidence. What happened, though, is Governor Pritzker didn't expect that here we are, even coming up to an election, that this would be a conversation our people, we wouldn't be paying attention. And it would roll in past the election, and it would be fine. And on January 1st, it'd be dealt with. But he already got reelected to his second term. That's what was going on. But now everybody's on top of this, thank goodness. And he's paralyzed, and he's trying to make up stories. What did he talk about the other day on TV? Well, the Safety Act, we don't want to have single mothers who might have taken some formula for their babies to be detained. And I just throw my hands in the air going, they weren't being detained anyway. And to the extent this law clarified that we're not going to detain them, okay. But that's not a justification for not being able to detain kidnappers and robbers and second-degree murderers. You're just going to not talk about that? And you try to say, oh, there's no such thing as a non-detainable offense. Yes, there is. I just explained it to you because you can only detain if they fit one of the 7 categories. And robbery's not in there. Kidnapping's not in there. Second-degree murder's not in there. There's no drug offense that's in there. That's the law that you're dealing with right now. That's the truth. And anybody, any place, anytime, Kwame Raoul, anytime, any place, day or night, you want to have a debate about this topic, about what I just talked about? I'm ready, because all I have to do is read it. All I have to do is call any of the state's attorneys, state of Illinois. Hey, you want to go with me and make Kwame look foolish? Because Kwame's the one that pushed this through, you guys. Your attorney general made this happen. He needs to own it. So there you go. That's what I got. I'm going to look and see if I can see a few questions that relate to the Safety Act. But I don't know if Ryan's seen any or not, because all I see over here is economy, and Trump, and all kinds of stuff that my God, come on, guys, help me out here. I'll touch on that one. Debbie Castile. I'll leave some of the more colorful words out, but what was the incentive to vote for this? I got 2 things to say for you about that. There's one of the arguments that's being made about the concerns of this bill by one of my Democratic colleagues in law, state's attorney at Glasgow, is that this bill has problems because it changes over 200 statutes. It's not just dealing with bail reform. It covers all kinds of topics we don't need to talk about. Why did they do that? Because they needed to put all these different topics into one bill to get enough people to vote for it. Because there are people going, I'm not going to vote for that. Well, what if we do this for you in the law that you'd like? Would you vote for it then? They start horse trading with your lives and your safety about, I'll give you this if you'll vote for the whole package. So sometimes when you're like, oh, I don't know why my legislator voted this way or that way because of a particular issue, it's because they can put all kinds of gobbledygook, that's a legal word, into the same law in order to coerce people into voting for it. That's one reason. The second reason is because of political pressure. Let me give it to you straight. Democrat and Republican alike, this is not a party thing. When you have certain influential people in a party that say, hey, our party thinks that this is a good idea and our party wants this to pass. And since you're a part of our party, you need to vote for this. And if you don't vote for this, next time you're up for election, you'll have a primary opponent that we're going to run against you, and the party will fund their primary race against you, and we won't support you. It happens every day. So there are people likely that voted for this that didn't necessarily like it, but they were pressured into do so. Because let me tell you something, none of them read it. Do you think they read 700 and some pages over that course of time? Of course they didn't. They didn't even know where they did an old Nancy Pelosi. You got to vote for it, see what's in it later, right? And no, they didn't read it. So it was political pressure, and there was something in there maybe that they wanted. It was one of the two, Debbie. Okay. Okay. There was another question Ryan just showed me over here. What can you do? What can you do right now? What can be these words call to action? I guess I've been hearing them a lot lately. Find out who your legislator is, if you don't already know, and call them. And go over and take the video that we just did. Say, do I understand correctly what Tom just said to me? Because what I just told you is the truth. I promise you. Call them up. Get on. You tell them you want to get on the record. You want to make them known what just happened. That's a huge issue, right? Tell them. I don't like that. I don't want kidnappers to not be detained if they need to be detained. I want the judge to have the discretion. Because really that's what this law was about, you guys. This law was about taking the discretion away from the judiciary, the judges, the state's attorneys, criminal defense lawyers, etc., taking the discretion away from them, and the legislature saying, we're going to draw that line. We're going to tell you who can be detained and who can't, right? And if they can be detained, then, judge, you can kind of have a little bit of say in the matter. But first and foremost, we're going to decide who you even have a say in the matter. You need to call your legislatures and talk to them about that, okay? Let me look here. Who said that? Ellen, each bill should only be allowed to cover 1 point. You know what? That's actually the law. It's constitutional. That, you know, the single issue. That's true. And actually, if you look at the lawsuit, Ellen, that Mr. Glasgow and I believe Mr. Howe, both Democrat state's attorneys have sued J.B. Pritzker, Kwame Raoul, and one of them, I believe, even sued the leaders of the House and the Senate, saying that the single issue has been, you know, standard has been violated because you modified 200 plus laws in one bill. So you're exactly right. That is a problem. Cassie, do you agree taking the judiciary out could be a constitutional problem? We'll be talking about that a little bit later, but yes, I do believe that's a problem. Yeah, and we've done a petition. Again, guys, you can go find it if you want. Ryan has it out there on. We're putting a petition together to repeal this Safety Act, and I'm going to personally deliver those petitions. Again, if we get enough of them, I'll deliver them to J.B. Pritzker myself. Okay, there's another thing that we talked about. Remember, we just went through these categories can be detained. These categories, if they're not in those 7, can't detain them. What's going to happen on January 1st? I lost track of state's attorneys and sheriffs across this state. They're the ones that know. So for everybody that they're holding in jail right now, there's a decision being made as we speak. Do they fit one of the 7 categories that we just went through? Or do they not? If they do not fit one of those categories, which includes kidnappers, burglars, second-degree murderers, there you go. They're going to release them on January 1st. Those are not my words. That's theirs. They're going to release them because they can't detain them under the new law. They're going to release them. For those that they believe may fit within the 7 categories, they have to have a hearing in front of the judge and let the judge then decide. Supposed to have that hearing within 48 hours, but how do you think you're going to have thousands of hearings in that much time across the state? Even you go into some counties, Madison County, for example. I can tell you, Madison County, the state's attorney there, who is competent of a person I've ever met, says half their jail is going to be released because they don't fit within the 7 categories. Half of his jail is going to walk the streets on January 1st because he's already decided that they don't fit any of the 7 categories. That's going to happen statewide. And the best I've been told, we could have up to 5,000 people currently being held. They're going to be released on January 1st. Let me keep looking here. I'm not going to touch on this a lot, Gina. Gina Jones says checks and balances between the House and the Senate. So any law can be defined as long as they wait for the lame duck session. That's a complicated conversation, but I will tell you, this whole process that I just explained to you of how they play these games with the gut and replace type of stuff, your House and Senate have broad discretion to create their own rules, and the courts don't like to weigh into those much. But I think there's a real constitutional problem, due process problem, for the people being involved in their government by having these legislators playing these games at 3 o'clock in the morning with this gut and replace stuff. I think there's a real constitutional issue there, and it's something as your next Attorney General I'd absolutely look into, because they're taking the people out of the process. We all know that's what they're doing. They're taking you out of the process so you never learn about any of it. How are you going to do a witness slip? You guys remember the witness slips that we've done recently? How do you do a witness slip at 3 o'clock in the morning? I mean, they're playing games, but we'll talk about that later, Gina. Let me see. Ryan, you see anything? Okay. Let me keep looking real quick. People keep typing in stuff. Oh, Jeff Crotty got in late, said, what are the 7 detainable offenses? Jeff, they're not 7 offenses. There's 7 categories of offenses. Ryan will post those out later, but there's 7 categories they have to fit in. Okay. Jeanette says, who was the 60th vote? I'm not going to say their name because I don't want to do that to them, but you can go find that out if you want to. Figure out the public record. I was told who it was in confidence. I'm not going to say their name publicly. Who said something about an executive order in here? Is there somebody watching this asking me if Darren Bailey could issue an executive order? You guys know you don't want to get me started on that. Of course, Darren Bailey is not going to issue an executive order trying to nullify a statute. Even if the statute has all kinds of legal problems, it does. We don't want a governor issuing executive orders. Come on, you guys. What have we been doing for the last 3 years? And Ryan's over there laughing, you guys. Okay, I'm about ready to be done here. I'm just going to look a little bit more. I thought I saw Jeannie Eyes might have posted something. I was going to see if she had a question. I will touch on that. Nicole Lynn says, Tom, this thing was passed in the middle of the night in 2021. Why wasn't anything said at that time? Not sure if my thought makes sense. Nicole, your thought makes perfect sense. You know why it wasn't talked about back in 2020? Now, granted, the legislature, the lame duck legislature, pushed it through within a few days, right? But you know why we didn't say anything? And you can put me in the category, that's okay, because we're all too lazy and complacent, not watching what our government's doing. Why do you think they can get away with this type of gamesmanship? Because they've been getting away with it for decades. Because we don't pay any attention, because we're busy going to little Susie's ballet dancing and our little Jimmy's soccer game, and your husband's golfing, and the wives do whatever they do. And again, don't say Tom's picking, because you put me right in there. We weren't paying any attention. And you know what? Yeah, we're paying attention now, right before an election, but we're going to pay attention January 2023 or February, what your legislature's doing. Take the Safety Act out of it, ma'am. Are you going to start paying attention? You, I'm saying all of us, not you particularly, Nicole. You're going to start paying attention? You better, because that's how this stuff happens in the first place. That was a good question. I'm glad you asked it. Okay, I think that's about it, isn't it, Ryan?
Yeah.
Okay, guys, that ought to do it. We're going to be back because I've got some more stuff on this. It's a broader topic dealing with it, but if you don't fit the 7 categories, you don't get detained, okay? So you don't have to use non-detainable offenses because the governors won't play words. You can ask, do you fit in the 7 categories? No drug offenses in there, no kidnapping, no robbery, no second degree. They're not in the categories, so you never make it to the judge. The judge never gets to decide. If somebody says to you, the judge has discretion to decide whether to detain you or not, the answer is maybe he does if it's a crime that's within the 7 categories. Because if it's not in there, the judge has no discretion. That's the truth. It's undisputable. Have a good night, guys. Take care.